Welcome to this explainer. Look, before we even get into it, I just want to take a brief second to acknowledge exactly why you're probably tuning in. Dealing with the loss of a loved one is incredibly difficult. And honestly, the mountain of administrative paperwork that follows, it can just feel overwhelmingly heavy. But hey, we are going to navigate this together. I'm going to guide you step by step to make this whole thing as clear and manageable as it can possibly be.
Like we say, losing a loved one is hard enough without the legal complications. Stick to the end of this explainer to learn how to smoothly navigate the title transfer process in Texas and protect your loved one's legacy. Honestly, my main goal today is to take what looks like a totally confusing bureaucratic maze and turn it into an empowering, predictable, step-by-step process for you.
So here is our roadmap for today. We'll start with your immediate first steps, unpack those Texas rules, map out the different ownership scenarios, walk through a concrete guide, flag some critical pitfalls you really need to avoid, and then point you to the best resources. 6 quick, manageable sections. Let's get to it.
Section 1, Intro and First Steps. Right off the bat, we've got to talk about why taking action on a title transfer so quickly is absolutely crucial. Now, you might be thinking, hey, can I just keep the car and keep driving it as is? Well, here's the thing. Under Texas law, you cannot legally register, sell, or even properly insure an inherited car without a formal title transfer. Now, Texas does give you a tiny bit of breathing room, a brief 30-day grace period to drive the deceased person's car, provided it has valid insurance. But listen, if that insurance lapses or if it actually doesn't cover you as a driver, driving without it can result in fines of up to $1,000. So yeah, you absolutely need that title in your name to protect yourself and the vehicle.
So, what are your immediate first steps? Number 1, you've got to track down the decedent's will or estate plan if they had one. That piece of paper is literally going to dictate the path we take a little later on. Number 2, and this is absolutely vital, guys, order certified copies of the death certificate. They have to be original, certified copies from Texas Vital Statistics or the county clerk, and they must have a raised seal or stamp. Please do not try to use photocopies or computer printouts. They will be immediately rejected by the tax office. Honestly, do yourself a favor and get several certified copies just to be safe.
Section 2, Texas Rules and Forms. Every state does things differently, so let's decode the specific rules and the alphabet soup of forms you need in Texas.
Okay, no matter what your specific inheritance situation looks like, there is one absolute non-negotiable constant, and that is Form 130U. This is the application for Texas title and/or registration. The new owner, meaning the person actually inheriting the car, has to fill this out. Just consider this form the anchor of your entire application package.
Now, while all these rules and forms are created by the Texas Department of Motor Vehicles, the TXDMV, you generally don't just stick this in an envelope and mail it to some central state hub. You're actually going to submit your final paperwork in person at your local county tax assessor collector's office. Think of them as the local, on-the-ground agents for the TXDMV.
So before you ever set foot in that county tax office, you have got to gather these 6 universal required documents. And this is where you can get really organized. Grab a folder and drop in your original certified death certificate, your completely filled out Form 130U, your valid government-issued photo ID, proof of Texas liability insurance that is actually in your name, an odometer disclosure if the car happens to be under 10 years old, and finally, the current vehicle registration or the VIN. Literally every single transfer is going to require those 6 items.
Section 3, Ownership Scenarios. Legal processes are basically a giant choose-your-own-adventure. Your exact path depends entirely on how the car was owned, so let's diagnose your situation. Okay, let's look at this chart. If there's a valid will and the estate has unsecured debts, you'll be going through standard probate to get official court approval, usually called letters testamentary, to manage the assets. Now, if there is a will, but absolutely no debts, you might be able to use a faster shortcut called muniment of title. This just validates the will without the whole drawn-out probate process. What if there's no will at all? You'll use an Affidavit of Heirship. And finally, if the owner placed a specific designation right on the title beforehand, while the transfer is virtually automated. Figuring out which bucket you fall into right now keeps you from getting totally bogged down by rules that don't even apply to you. Let's quickly compare the 2 most common situations we see. If your loved one left a will, the court usually has to validate it, either through full probate or a muniment of title order. But what if they didn't leave a will? A lot of people panic right here, but seriously, don't worry. Texas provides a really common workaround. It's called the Affidavit of Heirship for a motor vehicle, or Form VTR 262.
If the whole estate is valued at $75,000 or less, you can actually bypass probate entirely just by having all the heirs and two completely disinterested witnesses sign this notarized form. It is an absolute lifesaver.
Now, the easiest, smoothest path of all happens if the owner planned ahead. They might have actually filed a beneficiary designation, also known as a transfer on death or TOD, using Form VTR 121. Or maybe they set up joint ownership with rights of survivorship using Form VTR 122. If either of those is listed on the original title record, congratulations. You get to magically bypass the probate courts completely. You just stroll into the tax office with the original title, the death certificate, and that Form 130-U.
Section 4. Step-by-step guide. All right, now that you know your scenario, let's look at the physical, actionable workflow of actually getting this done.
Here is your simple 3-step physical workflow. Step 1. Gather those 6 universal documents we talked about, plus whatever scenario-specific form you need, like the court orders or that VTR 262 heirship affidavit. Step 2. You absolutely must address any existing vehicle liens. And Step 3. Take this entire pristine package of paperwork in person to your county tax assessor collector's office. You'll file it and pay the transfer fee, which is usually just around $28 to $33. Now, pausing on Step 2 for just a second, because we have to address a really critical question. What in the world happens to a car loan when the owner dies? Look, the debt does not just disappear into thin air. A car loan survives the owner, and that lien remains firmly on the title. The county tax office will absolutely not process your transfer until the loan is dealt with. So as the heir, you have a few choices. You can pay the loan off entirely to get a release of lien. You can formally assume and refinance the loan into your own name. Or you can just let the estate sell the vehicle to clear the debt. All right, so you successfully submit all your clean paperwork and pay the fees. How long does the whole thing take? Let's set some reasonable expectations right here. Standard title transfer processing times run about 2 to 6 weeks. The state is going to process your application and then eventually mail you a crisp, new Texas title with your name printed right on it as the legal owner. Section 5. Tips and pitfalls. As a total rule nerd, this is probably my favorite part. The insider tips and the very common mistakes that will get your paperwork instantly rejected. First up, I have a very strong warning for you if you are a transfer on death or TOD beneficiary. You do not have unlimited time here. You have exactly 180 days from the owner's date of death to apply for the title transfer. If you miss that 180-day window, the TOD designation is completely voided, and the vehicle could be forced right back into the complicated probate process. Seriously, do not drag your feet on this. Let's run through 4 major pitfalls you want to avoid. 1, like we mentioned, submitting photocopied death certificates. Just don't do it. 2, driving the car uninsured. Even during that 30-day grace period, the car absolutely must have active liability coverage. 3, trying to sell the car way too early. You legally cannot sell a deceased person's car until the title is officially in your name or you have explicit authority as an executor. And finally, number 4, this is a big one, forgetting the SB 2064 tax exemption. Thanks to a recent Texas law, most inherited vehicle transfers are now completely exempt from motor vehicle sales and gift taxes. So make sure you check the exemption box on Form 130-U. It will literally save you some serious money.
Section 6. Resources and next steps. Okay, you've got the knowledge. Now we're going to build a safety net of resources to support you actually getting this task done. Whenever you are ready to download Form 13-U, the VTR 262 affidavit, or really any other documents, go directly to the official source, txdmv.gov. You can also look up the physical address for your specific local county tax assessor collector right there on the site. For those certified death certificates, visit Texas Vital Statistics online or check in with your county clerk. And hey, remember, if the estate is complex, if it involves multiple heirs who are arguing, or if this just feels way too overwhelming right now, do not hesitate to reach out to a local Texas probate attorney for some legal assistance.
Look, I know this is a whole lot to process, especially during a time of grief, but just look at what you've learned today. You understand the forms, the timelines, the different scenarios and the pitfalls to avoid. So take a deep breath. Gather those universal documents we talked about. Identify which path your unique situation falls into, and just take it one step at a time. You absolutely have the knowledge to successfully manage this transition and protect your loved one's legacy.
And finally, a very necessary reminder.
This explainer is for informational purposes only and should not be considered legal advice. It's always recommended to consult with a legal professional for guidance specific to your circumstances. You now have the tools to handle this transition smoothly, but honestly, it brings up a pretty important point for all of us to think about. Have you organized your own paperwork so your family isn't left navigating this exact same maze? Thanks so much for joining me, and I'll see you next time.